grand theft and dealing in stolen property are very common charges in the state of Florida. Over the course of my career, I've handled many cases where the individual has allegedly stolen a product and then taken it to a pawn shop and sold it. Therefore, grand theft, if the amount of the product was worth more than $300, and then dealing in stolen property if you sold it to a pawn shop. Well, there's a fact that most folks don't know about, and that is Florida Statute 812.025 says if you are charged with grand theft and dealing in stolen property, that you cannot be adjudicated, found guilty, of both counts, of both charges. So if you're charged, and the state can bring both charges, and if it goes to a jury, the jury must make a determination of whether or not they're finding you guilty on the grand theft or if they are finding you guilty on the dealing in stolen property. The same goes for a judge. If you are negotiating a plea bargain and the state makes an offer which involves an adjudication or a withhold of adjudication on both a grand theft and the dealing in stolen property, and both of those counts stem from the same act or occurrence, if the judge accepts that plea bargain, it is an illegal sentence. The court, just as well as the jury, must make a determination whether or not the stolen property was taken with the intent to use for personal use, or whether the stolen property was meant to fence or traffic in stolen property. So keep that in mind, folks. If you've been charged with that, you cannot be found guilty of both counts. It's one or the other, and whether it's a jury case or whether it's a plea bargain, either the jury or the judge must make that determination. Thanks for listening.